that interpretation?
It can be small.
Can be taken. Then it will become a prerequisite that company is run as a going concern. Is it so? Is a prerequisite?
So I think in a company going under liquidation, going concern sale can happen only if there is some value which the buyer can see, not necessarily that the company has to be working. But there is some value, maybe like in Jet Airways or whatever,
correct,
where your operations can continue and the buyer can continue.
Okay.
It's
So,
strictly not a accounting definition.
Yeah. Perfect. See, it's all about the buyer who is going to get benefited out of it, not about it's something, legally it has to be established that the company is supposed to be a going concern. Though the concept has been now recognized under regulation, but it need not to be a going concern. Means it need not to be kept in a running condition as long as buyer gets benefit out of it. In fact, why I put this question is there are so many deliberation was given in insolvency law committee report. I don't know how many of you have got opportunity to go through that company law committee and insolvency committee report. Have you seen now insolvency law committee report? Have you got opportunity to see it anytime? Ongoing concern. I'm not asking in general sense. It very clearly deliberated going concern under liquidation. No. Okay, I'll take you through the report of the insolvency law committee as our one of our participants, the senior person, has he also shared that it is not that going concern should be kept as a running company, but of course it's all about the benefit that buyer is going to derive out of it, out of the sale as a corporate data as a going concern. That's what the provision says. So now going, okay, let me take you through one by one. Now the company during CARP, it has got a option, it explores. I'm just putting across the points to you. You can share. I'll take you through PPT. I have PPT. I have other inputs and report also. I want to run through relating to sale of going concern. All that I'm parking time being. But before that, I thought let us try to understand how the whole thing works. Now, see, you all know that once the company admitted into CARP, the CARP process starts. And of course, today it is up to 330 days. It can be, continued the CARP process. Then after that, the scheme process, the liquidator has to initiate the scheme process. Then after that, the liquidator has to give an attempt of sale of going concern. So there's a three, I should say that there's a three opportunity, three chances are given, okay, to buyer to take the company as a going concern. One is during the CARP by giving a plan. Two, by giving a scheme, the company can be taken as a going concern. Three, under regulation 32 of liquidation regulation, he has to take, from liquidator, it should acquire the corporate data as a going concern. So, in third option, is it? Do you feel that this going concern in liquidation is still really benefited, because after exploring CARP stage, after exploring scheme stage, after proving that the company is not, there is no takers in the market, after ascertaining, traveling that period during CARP and during the scheme period, we have got a 90 days time for scheme period. After that, once there is no taker to take over the company, acquire the company as a going concern, then it is pushed to liquidation. But even during liquidation also, you feel that is it a better option that in liquidation also to explore the same thing, because it's time taken, right? It's time taken, again time taken. Already which is explored in CERP, explored in the scheme, again the same thing in a different manner, calling it as a sale as a going concern. So we are going to repeat the process the third time, right? Is it so? That's why I asked you that how it is workable. Is it really working? What is your personal view on that? What is your input on that? Is it really more beneficial? Of course, I understand buyer is getting benefited. But after exploring CERP, after exploring scheme, even in liquidation, is it required? Regulation is there. We are going to discuss. I'm just practically I'm asking your experience and inputs. How it possible practically to do that? How to do that, first of all? How to do a sale as a going concern, okay, in liquidation? Is there any specific provision except that one line in regulation 32, sale of corporate debtor as a going concern under regulation 32E? Except that, is there any provision in the entire code, whether in the IBC code or in the Companies Act? Is there any provision how to do it? Just you can share your views, no? We are all handling that. Just you can share your inputs so that we will see how to develop it. If need be, we can even give suggestion to institutions also to take it forward. Is there any provision, specific provision? Is codified in the code or in the Companies Act? How to convey, how to do sale of corporate data as a going concern? Is anything codified in the law? The process and procedures, how it would be carried out? Please give some inputs, no? No. Can we take it? No. There is nothing there. Then how to do it? Question is then how to do it? It's the question. When there is no provision as to how to sell the corporate data as a going concern, there is an enabling provision under the regulation to sell the corporate data going concern. But what process has to be followed? What procedure has to be followed? Is it specifically provided in the code?
Sir, I don't think there is a specific provision which is provided under the code, and that is the reason probably IPs are facing much more practical difficulties and unseen problems while they are handling such cases. And then when the IP took a decision, probably they are facing the hit from the NCLTs. So correctly, I mean, I myself has handled a couple of engagements with my partners, and as the guideline were not there, probably, we were able to, there were quite a lot of problems which we faced to complete those cases.
So you completed?
Yes, sir, we completed one case. The other case is still pending with NCLT because the client has asked for reliefs.
So the sale of corporate data as a going concern is only can be carried out with the direction of honorable adjudicating authority, because there is no extra source in the code. So
absolutely, sir.
Whatever liquidator does, it can be questioned.
Yes. Yes.
There is no regulation, there is no provision.
There is no provision. I mean, we have a specific provision for a CIRP process or a liquidation process, but not for going concern liquidation.
But see, the concept has came into the regulation long back.
Absolutely, sir. And there is supposed to be a clarity by the IBBI or by the government how to handle a practical issues, which probably so far we are still struggling.
I can show you some, as you said, some 15 orders I can show you on sale of going concern. Every order is dealt with in a different manner, different fashion.
Absolutely, absolutely.
So, at the end of the day, what needs to be followed is that clarity emerge. We can deliberate next 2 hours, 2.5 hours on sale of going concern. We can deliberate, we can share our experience, all that we can do. But I'll say that all we can do, but still it is not codified in the law. Of course, certain things are provided in the orders of Honorable Adjudicating Authority, no doubt. It is provided, but still can they be taken as a law to proceed further by liquidator? I can show some 10, 15 orders of the Honorable NCLT. But every order gives different reliefs with different observations, limitations. So what to take, what not to take. And there is no provision in the law. But we have to discuss 3 hours for this, right? So what is yeah. No, not audible, not audible.
Hope to get some knowledge from your experience, so that we might get some help in our ongoing cases or future cases.
I don't know this particular topic. I don't know. See, since participants are keeping silent, so I thought, okay, they would not have experienced that. So that means they are enjoying the comfort of not experiencing these challenges. Okay, good. Then we should only tell them, okay, good. At least till the law, get settled. At least you will be in peace. At least, but person who is handling, he will undergo all pain.
Yes.
Hello.
Yeah, tell me. Yeah, tell me. Someone was trying to talk. Oh, is it crosstalk? Okay, I thought something you wanted to tell. Okay. See, from where to take? No, it so happened. Incidentally, this particular topic, sale of going concern, has come to me for deliberation. I don't know, accidentally or incidentally, the whole concept emerged out of my own case law in Honorable NCLAT. It is only. Hello, yeah, please tell me. Yeah, tell me. Mr. Anil Kichar. Sir, do you want to tell something? Don't know. See here, the whole concept, that the sale as a going concern should be tried. In fact, if you have to say the mood, the starting point came, it came into light. Okay, from the case law, you must be knowing, or I will tell you what is that case law, wherein it was a case where I happened to be a liquidator of that matter. The first time Honorable NCLAT, when the liquidation gone on appeal, the first time Honorable NCLAT and completely gave out what are the process to be followed during liquidation, what the liquidator supposed to do during the liquidation. So that was the first case, which literally deliberated about a sale as a business of the corporate debtor as a going concern. Before that, that going concern concept in liquidation was not deliberated. Okay, the same way the scheme also was not deliberated. How to combine the scheme. So that's why I told you that the corporate debtor can be acquired by the buyer during CRP by giving a plan, option 1. During scheme, stage by giving a scheme, option 2, okay, or stage 2 we can say. The third option is that, and if the buyer could not make it out, or maybe may not be knowing what is going on, about particular matter, suddenly he comes to know in liquidation, oh, some company is available in going concern, and again now that point of time also the buyer is getting an opportunity to take over the business of the corporate data as a going concern, or so it's more of giving free hand to buyer who is going to acquire, who are missed out in CERP and scheme stage. Again they can come in the liquidation stage. That's the benefit the buyer is getting. Okay, now I will share my screen, then I'll take you through the first case law, the order which I referred. It's my own order, direction given to me as a liquidator by Honorable Enclad. Then I'll take you through to my PPT, and I'll try to share my experience, whatever how Madam Mitali Shah has shared her experience. So similar way, I will also try to share a few of my experience, and because it started, in fact, I should say it has been what we say ignited through me in my order, through my order. So I'll share my screen, then probably I'll take you through to that order. So these are the order which I was referring to you. Okay, these are the orders of sale as a going concern. That there are many orders passed by Honorable Enclad, but unfortunately there is no clear-cut code has emerged out of that what needs to be followed. Okay, that's the question that I had raised now. To take you from, yeah. Okay, so now just a moment. Yeah, this is the order passed by Honorable Enclad in the matter of Y. Shivaram Prasad versus S. Dhanapal, which is none other than me. It's me only. No, I am the respondent in this matter, wherein the order came to be passed by Honorable Enclad on February 2019, so 27th February 2019, in the matter of Lakshmi Paper Limited. Okay. Now, why this order is important? Why I need to start this order? Because this is the first order whereby Honorable Enclad Appellate Tribunal has given a clear instruction, direction to liquidator that what liquidator has to do. Before that, there was no that specification given in that detailed way. See, this is the first time where, if you see, section 230, entire section has been reproduced in the order itself by Honorable Enclad. So they reproduce the entire section 230 to give a direction to the liquidator. That liquidator has to first to explore a scheme option, then to go on to the sale of business as a going concern. Yeah. So here it is very important from here, because I showed you these are all standard matter section 230 of the Companies Act 2013. Okay. Now the Honorable Enclad has observed, okay, stating that in view of the provision of section 230 and the decision of Honorable Supreme Court in Mehra Homes and Swiss Ribbon Private Limited, we direct the liquidator to proceed in accordance with the law. He will verify claim and take custody. Okay, and they no actionable claim of corporate data and carry on the business of the corporate data for beneficial liquidation as prescribed in the 35. So now what he said is liquidator will access information, will consolidate the claim. After verification, let him do admission, rejection, all that let him do. Okay, but before taking steps, this is very important here. There's a clear observation by Honorable Enclad stating that before taking steps to sell the assets of the corporate debtor company herein, the liquidator will take steps in terms of section 230 of the Companies Act. What I would suggest you, if you have any doubt, you can put me then and there. We will discuss, then we'll move on. Because it's not that something you can park at the end, because something, you know, this whole concept itself has to be deliberated more to find a suitable solution, actually. In fact, the topic itself, sale of corporate data going concern and, challenges and a suitable remedy for that. So we will try to deliberate and find out, some solution for that. And uniform solution. So solution is there. There are a lot of solutions given by Honorable NCLT in various orders, but a uniform solution has to come. So here in this order, you see very clearly the Honorable Enclad has ordered, before taking steps to sell the assets, the liquidator will take steps in terms of section 230. What 230 says is a scheme. You all must be knowing section 230 is for scheme of compromise or scheme of arrangement to be filed by company creditors. Now, further, it went on to say, the Honorable Enclad, further it said, the adjudicating authority, if so required, will pass an appropriate order. Only on failure of revival, only if that failure of revival, the adjudicating authority and the liquidator will first proceed with the sale of company assets wholly, and thereafter, if not possible, to sell the company in part and in accordance with law. So this is what the order, the very first order by Honorable Enclad in this matter, wherein it gave a clear instruction, direction to the liquidator. So further it went on to say, therefore, it is clear that during the liquidation process, step required to be taken for its revival and continuation of corporate debtor by protecting corporate debtor from its management and death of the liquidation. In fact, this same order, the Honorable Enclad order in Shivaram Prasad versus Dhanapal, has been referred and been taken by Insolvency Law Committee report 2020. The same order has been taken. The same content also has been considered, deliberated by the committee, and they gave a final this thing. Then what what should be the proper recourse going forward after exploring all these options. Okay. Now, so what Honorable Enclad went on to say is that after doing this process, revival and by protecting corporate data from its management from death of by liquidation, the steps which are required to be taken are as follows. What are the steps? By compromise arrangement with the creditor or class of creditor members or class of member in terms of section 230 of the Companies Act. On failure, the liquidator is required to take steps to sell the business of the corporate debtor as a going concern in its totality along with the employees. So, in its totality along with the employee, this is what the order of Honorable Enclad. So the last stage will be the death of corporate debtor by liquidation, which should be avoided. So this is the order passed by Honorable Enclad in the matter of why Shivaram Prasad versus Dhanapal. Okay.
So I have a couple of questions at this stage. One is section 230 is still applicable. It has not been wound up, so to say, not been superseded by the IBC. And the second question is this whole process mandatory even in liquidation?
Yeah, today it became mandatory.
Today it is mandatory.
Today, there's a regulation. I'll show you the regulation also. Today it became mandatory by virtue of 2B, regulation 2B of liquidation regulation, wherein the liquidator has to take steps to see that he is receiving the scheme. Then after exploring the scheme option only, you should pursue it to the liquidation. It almost now the regulation came into force after this this order of the Honorable Inclad. I'll show you the regulation. That is one thing. The second question, what you raised?
Is section 230 still applicable?
Yeah, it's very much applicable. Any scheme which is contemplated during liquidation, before proceeding for liquidation, any scheme contemplated, the scheme can be contemplated only under section 230. There is no other provision except at section 230 of the Companies Act. There is no provision in the Insolvency Bankruptcy Code for contemplating a scheme, how the scheme should be contemplated, unless the reference is taken from section 230. Section 230 necessarily has to be followed in the scheme process if the scheme is contemplated. And if the scheme is submitted to the liquidator, then that provision section 230 has to be followed. That's why I told you the entire 230 provision is reproduced in this order. What they mean to say, Honorable Inclad, what they mean to say is that you have to follow section 230. That's why they reproduce the entire provisions of the section 230 in the order itself, where they are trying directing the liquidator to persuade to proceed with the scheme, inviting scheme under section 230.
So is there any positive closure for section 230 under IBC so far?
Many orders have passed. Many orders have passed. Many companies are taken over under section 230. Even after my case, 20-year Lifeline, one hospital company also, they in 230 only they acquired after my order. So many cases order has been. Many cases ordered and is for 230 through 230, and many cases ordered for sale of corporate data. But here, unfortunately, there are many orders are in place, but there is no uniform code in which how it should be contemplated. The scheme, how it should be dealt with. How the sale of corporate data should be dealt with. There is no clarity in that. That's why I put that question to you also. Because about more than 55, 56 professionals are sitting here. Right? So if we are not having answer, then who is Yeah, tell me. We're not audible. Anyone want to say something?
Is it possible to go directly to liquidation with the consent of, I don't know, the creditors or newspaper without having to necessarily go through the scheme process? Now,
Sorry, can you repeat? Sorry.
so we see in liquidation possibility of making a sale ongoing as a going concern is going to be very, very challenging and difficult. It may almost be a theoretical possibility in most of the cases. Is it possible for the liquidator to directly go to liquidation without having to go through this process of trying to sell as a going concern?
Then I have to take you through. Right, just a moment. I have a PPT. I'll take you through, but before that, I thought I should, make you to, understand where we stand. Then we can move on. Then see, this is the now I told you, no, regulation 2B has been inserted after the cases which I referred, after the order of Honorable NCLAT. This regulation 2B has been provided, where a compromise or arrangement is proposed under section 230. Even in regulation itself, they made it clear that compromise arrangement has to be proposed under section 230. Okay, it shall be completed within 90 days of the order of liquidation under section 33. Then it says the eligibility, non-eligibility of a person who is not eligible to submit a resolution plan. He is not eligible in this scheme also. He is not a party, should not be a party in scheme also. Okay. Then again, I know there is a amendment came when it's further proviso has been introduced, whereby it provided further that where recommendation to explore proposal of compromise amendment has been made by committee under 39 BA of CRP regulation, the liquidator shall file the proposal within 30 days of the order. I here only, you know, it says I wanted to understand. It says liquidation shall file. That means once the COC, the recommendation has come, okay, to explore the proposal by the committee under 39 BA of the CARP, it makes mandatory on part of the liquidator that he should file a proposal. File the proposal. That means the proposal should be in hand within 30 days of the order. That means when the proposal is in hand, the liquidator should make sure he is filing the proposal after verifying the legality, you know, and completely within 30 days of the order of the liquidation. If a proposal is in hand, then the time taken on compromise arrangement shall not exceeding 90 days shall not be included in the liquidation. That means the liquidation period of regulation 44, which gives the timeline of 1 year. For calculating that 1 year, the provision says the time taken on compromise arrangement not exceeding 90 days shall not be included in the liquidation period. That means we get 90 days extra apart from the liquidation period of regulation 44. So any cost incurred by liquidator in relation to compromise shall be borne by the corporate debtor, where such compromise granted by the tribunal under. Okay, this is what the provision. So therefore, if there is a scheme and there is no other option, the liquidator has to explore the scheme. Okay, then he has to proceed further. Hope you are getting the point. I think someone has raised the point. So after amendment of regulation 2B, after introduction of 2B, now it all the more, the liquidator became duty bound. Okay, where a scheme and arrangement is proposed, that is filing with the Honorable NCLT within 30 days time. And to make sure that the process is completed within 90 days time, as per the direction of adjudicating authority, of course, subject to the provisions of section 230 of the Companies. This is what about the scheme under section 230 of the Companies Act, which has been contemplated in the order which I was showing you. Now coming back to the order. I think see here in this order, I was reading up to this side, because very important this. In fact, this only is a root cause for the entire amendment that took place in the liquidation regulation. This was the root cause, and after this order, IBBA has taken up the changes, into the. They brought the changes into the regulations after this order. So here, if you see, it is very clearly said, normally the total period for liquidation is to be completed preferably within 2 years. This appellate tribunal allowed a 90 days time to take steps in under section 230 of the Companies Act In case for any reason liquidation process under section 230 takes more time. So here it says liquidation process under section 230 takes more time. It is open to the adjudicating authority to extend the period if there is a chance of approval of arrangement of the scheme. That means can be extended. These are the direction given to the liquidator to follow. Now, by virtue of this, there was an amendment brought in by the IBBA, whereby the amendment has been introduced in the form of regulation 2B, which I showed you. Now, further, but this is the fundamental actually, based on what the whole changes have come. Now, further, it says during the proceeding under section 230, if any objection is raised, it is open to the adjudicating authority, which has power to pass order under section 230 to overrule the objection if the arrangement and scheme is beneficial for renewal of the corporate debt. While passing such order, the adjudicating authority is to play dual role, one as a AA in the matter of liquidation, other as a tribunal for passing order under section 230. As the liquidation is so taken up under INB code, the arrangement of scheme should be in consonance with the statement and object of INB code, meaning thereby the scheme must ensure maximization of assets of the corporate debtor and balance the stakeholders such as financial creditor, OC, and secured creditor and unsecured creditor without any discrimination. Further, he went on to say, before approval of the arrangement of scheme, the adjudicating authority should follow the same principle and should allow the liquidator to constitute a committee of creditor for its opinion. Only for the limited purpose of taking opinion, the committee of creditor will be constituted to find out whether the arrangement of scheme is viable, feasible, and having appropriate financial metrics. So it will be open for the adjudicating authority as a tribunal to approve the arrangement in spite of some irrelevant objection that may be raised by one or other creditor, and then keeping in mind the object of INB code. So after telling all this, the direction is given to the liquidator that in view of the aforesaid observations, we hold that the liquidator is required to act in terms of aforesaid direction of the appellate tribunal and take steps under section 230 of the Companies Act. The members of the corporate debtor and creditors or class of creditors like financial creditor, operation creditor approach the company through liquidator for compromise arrangement by making proposal to all the creditors. The liquidator on behalf of the company will move an application under section 230 of the Companies Act before AA. That's why if you see the regulation 2B of
104 टावर की बोला तो बस है ना वो तो बोलते हैं दूर ही बेटर रहेगा इतना दूर ही बेटर रहेगा
I think someone
मैं आऊंगा
Participants, can you mute your mic? Please mute your mic. Yeah.
So how has this been taken care of in the regulations, this whole process of setting up a committee of creditors, this whole etc.? How has it been taken care of in the amendment?
All these not fully taken care by the, as I was referring earlier, by virtue of this, this order, Honorable Inclat went on to, I was showing the regulation, right? That 2B, by virtue of the order of the Honorable Inclat, the IBBA went on and introduced this provision by an amendment. They have not taken everything from the order and they, stuffed here or they introduced here. They only taken the intent of that order and they put it as regulation 2B. So if you have to have more clarity, we have to go and get a clarity from Honorable Adjudicating Authority or from a clarity from the Order of Appellate Authority. By virtue of that only we can move on. Regulation does not provide the entire thing, how it should be dealt with. Hope you are clear. IBBA, that regulation which talks about compromise and arrangement does not provide how it should be dealt with, what is to be followed under Companies Act, what need not to be followed under Companies Act, and what is to be followed, for compromise arrangement under Section 230, how it should be dealt with. It only says that where a scheme or compromise is there, it shall be completed within 90 days. When the committee suggests the compromise there in the hand of the liquidator, you should make sure that he is filing the scheme within 30 days time from the date of the liquidation. And it is excluded, that 90 days time is excluded. This is all about covered in the regulation. Rest of the thing, we have to go by the directions or instructions from the adjudicating authority, whoever dealing with the matter. With whom the matter is presented, or before whom that matter is presented, we should take a clarity from them. Then how to move on.
So is there an action with IBBI to have a complete regulation in the matter? Has that been taken up with the IBBI by the IP bodies?
I don't think so. We have to ask organizing team only. There any points have been taken and given. Probably with this discussion, probably we can request IACSA, IAP to take it and represent and give suggestions to IBBA to amend the regulation, bringing, of course, many amendments are coming in, but I don't think so. Amendments are coming in, giving more clarity on scheme and going concern, that aspects. That's coming in a different angle. Amendments are expected in a different set of things, not on these.
Because this is quite a unique situation in IBC. Normally, the regulations are pretty articulate and clear. This is one very strange thing that they still go back as per an order to refer to Section 230 and still don't give a complete direction as to how a process has to carry on. And again, this is a very theoretical process because normally you wouldn't expect in liquidation to be able to sell that on a going concern.
Yeah, absolutely. Yeah, it's a very unique situation. We don't have answer for all situation in this, and we have to go by the orders then and there. Whatever given passed by a honorable adjudicating authority. Based on that only, it has to be moved step by step. There is no clear-cut process. Just like under Companies Act, how it says about how the scheme has to be contemplated and what is the process to be followed, what is the approval process, and all that is not, whatever is applicable for the scheme which is contemplated under the Insolvency Bankruptcy Code, that needs to be followed, has to be followed. Whatever applicable, okay? And in many matters, I think the matters the Honorable Adjudicating Authority has given a directions, to the scheme applicant and liquidator to comply certain provisions, seeing the situation. Not everything in the what is provided under 230 of the Companies Act, which is not possible. Because here you can't get approval of more than 75% of the members, majority in number and more than 75% in voting, which is not possible. That fundamental itself is not possible in if a scheme is contemplated under IBC. Because under IBC, that the process, the liquidator and the creditor and shareholder, you can't have a same set of process which we are following under section 230 under the provision of Companies Act. What are the scheme conduct under the provision of Companies Act? Same, all those process cannot be followed. Okay, few can be followed, few cannot be followed under the insolvency bankruptcy code when scheme is contemplated before the liquidator. No doubt, I think we have to wait how things are emerging. We have to wait and see. Same the situation for even sale of going concern, sale of a corporate debtor as going concern. Same the situation. Clarity should emerge. Much more clarity should emerge to see that we are easing out. In fact, my whole deliberation itself, I thought that the first half I can talk about the challenges, what are all there, and how it has reached, how we are all reached to this stage. From the stage of May 2016, you must be knowing when the code has introduced. From that stage to today where we are, how we reached to this stage, how the law got amended, how things have got evolved. So I wanted to discuss this for first 1 hour or so that we will see going concern sale, how it can be dealt with. Maybe with the given orders in hand, whatever the orders in hand and what are the experience that we have in hand. With that, we can try to discuss and we can try to see how going forward things can be taken care of. When sale is carried out, sale is done as a going concern, corporate as a going concern, or business of a corporate as a going concern. So we will try to see that we deliberate and take more takeaways. Before that, I thought first the part of our deliberation should be from where to where we reach today. From the stage where which it talks CRP and liquidation, only two, nothing more, and the IBC is possible. From that stage, after order passed by Honorable Inclat, I was showing. After these orders, things were got different shape. Then IBBA brought in amendment, and after amendment, the scheme is introduced. Then again the question came before them that why not sale of going concern? Why not it should be tried? Okay, let's try that also. That also introduced. Where is the set of principle and courts? There is no set of principle and courts. We have to go by the orders of the Honorable Adjudicating Authority and Appellate Authority, wherever it is, to whatever it is available, wherever it is available. If there is no clarity, we have to approach Adjudicating Authority for better clarity. So that's what the position today. The position is to improve. No doubt, it is to improve. I wanted to, now this order I showed you, now I think you would have now understood where it starts, how it started. Whole episode, how it started, you would have seen. So, by this order is very important order, wherein it very clearly says what should be done by the liquidator once the company comes into liquidation. So now, if you see, I'll take you through the committee. I think committee report. Just a moment. I wanted you to take to committee report. Looks like I closed report. Okay. Fine, I'll get you now. So this is the report of the committee. Okay. Okay, this report, it's very important to understand this. Because now you understood till the order of Honorable Inclet, what they said and what they gave a direction to liquidator and how the things have got amended subsequent to the order. Now, if you see this report of the Insolvency Committee to improve the Insolvency Bankruptcy Code in February 2020, almost after a year of the order of Honorable Inclet. By then, the amendment has come into place, has been given effect. Okay, in that if you see, so here if you see the observations, what are the points given by the committee, I'll take you through in detail of that. The committee said this particular point, the report, Insolvency Committee report, the scheme of arrangement in liquidation. It is being observed that section 230 of the Companies Act 2013 is not aligned with the liquidation process of the court. And two processes may not be compatible. Therefore, it is being recommended that recourse to section 230 of Companies Act for effecting schemes of arrangement because should not be available during liquidation of the corporate debtor under the code. However, a need is felt that an appropriate process to allow the liquidator to effect compromise or settlement with the specific creditor should be devised under the code. So they gave a observation comment saying that section 230, both are not going compatible. So better to devise a method, a scheme, wherein the liquidator should be positioned to effect a compromise or settlement with a specific creditor under the code. But it cannot be done or should not be done. It's a recommendation given by them. Okay, that 230, because as I was telling, there's a practical difficulties involved. So therefore, they gave this sort of recommendation. If you want to understand better, we have to go to page number 68. 68, it talks about process, liquidation, and the scheme, and how sale of going concern. Okay. If you see the committee report, it's very important to note. So I think one of the participants also raised this query. You will understand better if you read these particular points. Please understand again, I am going to discuss with you how to contemplate, how to do the sale of going corporate data as going concern in last 1 hour. I am keeping that part away. I have not touched upon so far how sale of corporate data as a going concern could be rendered. That part we will be discussing last 1 hour. Okay, now I am just exploring why it has come. Only when we explore, try to understand why and when and how it came, only we'll be in a better position to appreciate when a situation comes to handle. Okay. Without knowing the background and history, it is difficult to understand the provision of law, and implement the provision of law. That's why implementation side, implementation of scheme or implementation of sale of corporate data as a going concern, I'm little parking it at the end of the session. Maybe 45 minutes to 1 hour. I'll deliberate how it can be deliberated. We'll see various orders also for that. But here now, I wanted to say what is the view of the Insolvency Committee and what was the order that was passed by Honorable Inclet and what was the amendment brought in by the IBBA after the order of the Honorable Inclet, which introduced the scheme process and the going concern process during the liquidation. Because going concern is there already in CRP, but during liquidation it was not there before the order passed by Honorable Inclet. So how it is evolved, that only we are trying to understand. Now, if you see the Insolvency Committee, Law Committee, they gave a recommendation in that report what they deliberated about scheme of arrangement in liquidation. Heading itself, scheme of arrangement in liquidation. Okay, it is not scheme of arrangement under Companies Act 2013. Okay, in liquidation. Section 230 of the Companies Act 13 as amended by the 11th schedule of the code allows for scheme of arrangement to be proposed during the liquidation process under the code. So section 230 of the Companies Act as amended by the 11th schedule of the code that allows for a scheme of arrangement to be proposed during the liquidation process. What is that amendment in 11th schedule? What kind of amendment it brought in? Let's see what kind of amendment it brought in. I'll take you through in Companies Act. I'll take you through in the Companies Act. This is section 230 in the Companies Act, 2013. Power to compromise to make arrangement with the creditor and members where compromise amendment is proposed. Okay. Now, the amendment in Schedule 11 of the IBC, what amendment it brought in the Companies Act, which was instrumental, which became the instrumental for Honorable Enclad to introduce the process stage called scheme, stage called the sale of corporate debtor as a going concern. All this is the amendment, main amendment, which is the root cause for the entire thing. The tribunal may, on application of the company or any creditor or member of the company, or in case of a company which is being wound up of the liquidator. So a liquidator also can file a scheme. That's what it contemplated. Originally, it only says of the liquidator. That means liquidator and the Companies Act also. Okay. It referred originally the liquidator of the Companies Act. But here, if you see, by virtue of amendment brought in Schedule 11 to the Insolvency Bankruptcy Code, whereby the amendment, there were insertion under section 230, subsection 1, wherein the liquidator, it is expanded by inserting not only the liquidator under the Companies Act, it is also liquidator appointed under this act, that means under the Companies Act, or under the Insolvency Bankruptcy Code, as the case may be. So they took a view stating that since the amendment has been brought in, the code amended that the scheme can be contemplated even by the liquidator, why not scheme should be contemplated? This is the moot question that was before the Honorable Appellate Tribunal. So Appellate Tribunal went on to say it is very much permitted that liquidator, if scheme is in hand, he has to first ensure he is persuading with the scheme. On failure of that, then he should move on to first try to sell the assets as a going concern, means the business of the corporate debtor as a going concern. But before that, the scheme proposal or the stage has to be explored. The process has to be explored, scheme process has to be explored. Okay. So now, by virtue of this amendment, appointed under this act or under Insolvency Code, that means an application not only by the company, not only by the creditor, not only by the member of the company, also the application of the liquidator appointed under the Insolvency Code, the tribunal may pass the order. That's what it concluded. That's what it gave a kind of completeness. Then the Honorable Appellate Authority went on to say that scheme has to be implemented. Good. Scheme has to be implemented. How? By following what? By following 230 of the Companies Act. Okay. So whatever not possible practically to follow, that Honorable Adjudicating Authority has to decide what is possible, what is not possible, what is permitted to be rendered by the liquidator, what is not permitted to be rendered by the liquidator. All that is left to the Honorable Adjudicating Authority to decide accordingly to direct the liquidator to contemplate the scheme, to file a scheme and complete the scheme process. Hope you are all with me. This is how the scheme has been introduced under the Insolvency Code during liquidation, after CER, during liquidation. Okay, this is how the whole concept has came in. Of course, the scheme can be contemplated not only under liquidation. I'll take you through in my slide. Okay, because if you see the definition of resolution plan, that definite resolution plan itself include scheme of merger and demerger. Okay, the resolution plan itself, the definition given under the regulation, CRP regulation, that includes scheme. So scheme, not only it can be contemplated only in the liquidation, it can be contemplated even in the CRP. That's what the insolvency committee, they went on to say. I want to read that to you so that you will understand what exactly the committee wanted to say, wanted to recommend. Okay. Now their committee says, okay, it was brought to the committee that prima facie section 230 of the Companies Act is not aligned with the process of the code. And concern has been raised by the stakeholder that the two processes may be incompatible. For example, section 230 requires meeting of the creditors and members. Also envisages an elaborate voting process for approval of the scheme that requires agreement by majority of person in numbers representing 3/4 in value of the creditor or member. Such a requirement of creditor and shareholder participation and approval are at odds with the liquidation process of the code. Since the code does not envisage such an elaborate voting process for approval that involves creditor and shareholders of the corporate debtor. This is the recommendation, this is observation given by Insolvency Law Committee. Okay. The next observation, what they gave, the approval and implementation scheme under section 230 of the Companies Act during a liquidation process of the code require the NCLT to play dual role, right? Because which came from the Honorable Enclave order. I would have showed you that. Honorable Enclave went on to say that adjudicating authority has to play a dual role. One as a NCLT, another as an adjudicating authority. Same they observed in the committee in their report, stating that NCLT to play a dual role as an adjudicating authority for liquidation process, as a tribunal for sanctioning the scheme as per Companies Act 230. However, the role of the NCLT the role of NCLT and the consideration that have to be taken into account in both cases would be vastly different. Both are different. Schemes are broadly tribunal-led process, which the NCLT has vast power to pass any direction and supervise the implementation of the scheme. On the other hand, the liquidation process under the code is led by the liquidator under the supervision of the adjudicating authority. That means the liquidation process is led by liquidator. Means the liquidator is instrumental to the entire liquidation process. Of course, under the supervision and direction of the adjudicating authority. But it is the liquidator and adjudicating authority both are instrumental to the liquidation process. Whereas in the scheme, only the NCLT alone is a instrumental or is a decision maker. That's what the recommendation difference highlighted by the committee. Again, what they are saying, scheme are not time-bound processes, whereas the focus of the code is to create a time-bound process. Even liquidation process sought to be completed within a year to prevent value destruction. It is required of creditor. Same way 29A 35(1)F promoter and certain related parties from acquiring no such bar. That's why that bar has been introduced. No such bar is imposed by the language of 230. But now this bar has come under 2B, regulation 2B. I showed you that regulation. See, regulation 2B, there's a bar. Whatever committee says it is not in the Companies Act, but it is there in the Insolvency Code. Who is not eligible under the court to submit the plan shall not be party in any manner in any of the compromise. So here this provision very much is there. But committee concern is different. See, committee's concern is it is not in Companies Act. Okay. Same way at the same time, committee noted that various judicial innovation efforts of the IBPA, that has been moved to align to two regimes, for instance. A appellate authority has interpreted that class approval may not be required for schemes in liquidation in the court, but has held the liquidator must constitute the creditors committee to assess if arrangement scheme is viable, feasible. However, such process is also patently at odds with the original scheme of the code. That means that the scheme of a code is different, but introducing new process. That's what the report says, which does not envisage the creation of such a creditors committee in liquidation. In liquidation, there is no such requirement to create a committee, which was there in the order. That's what the observation given in the committee report. Same way as the promoter and ex-management were presenting the scheme in liquidation on the basis of 230. This resulted in prolonged litigation under the code. In case if we permit the promoter ex-management people to present the scheme, then again it is becoming a prolonged litigation under the drawback. That's what I highlighted. Only recently the appellate authority expressed a clear view that the promoter were not eligible under 290A are not entitled to fine. They themselves told that Honorable Appellate Authority has clearly told that also. Thereafter, the liquidation regulation was also amended in January 2020, and they provided that those which I showed you, that also they observed, which I showed you, that it is today it is there that they should not be party in the compromise. While the liquidation will clearly provide timeline for completion of scheme, it is unclear how the scheme process can be completed within this period. Okay, so how it could be completed? Because a lot more process is involved. Okay, since the design of the process of scheme under Companies Act does not envisage this. Okay, so that because there is no separate timeline given how it should be done under the code. Of course, there is a clear-cut parameter design is given under the Companies Act 230. How same can be done under liquidation? There is no clarity on that. That's what the committee also says. Further, it is unclear how the failure of our premature termination scheme will be dealt in practice. Thus, despite alignment difficulties in the implementation of scheme continue to persist. Okay, so here committee has given a again as I was referring, they gave a very blanket recommendation or comment, I can rather say that. Okay, here they went on to say the committee report. The committee noted the scheme are being mandated and used as an option to revive the corporate debt before proceeding with the sale of assets of the corporate debt. Such a scheme presented as a second chance to resolve the corporate debt. Okay, it is second chance. First is the CRP. Second chance is the scheme. May not always be feasible, economically viable once the decision to liquidate the corporate has already been made following the failure of the CRP. That means committee is on the view that when CRP itself they failed, how could there is a hope in scheme it will come revived when CRP itself is not revived? Because during CRP itself scheme can be presented. Then why not, then why separately there should be in another stage after CRP there is another scheme stage. That's what the recommendation, that's what the observation made by them. Notwithstanding that scheme may not be well tailored to resolve insolvency, allowing the revival after CRP has failed would alter the incentive of the creditor to resolve the insolvency initially. So repeatedly attempting revival through scheme of arrangement or otherwise, even where business is not economically viable, is likely to result in value destruction delays and was identifiable as a key reason for failure regime under SICA by the BLRC in its interim report. So such use of scheme is also inherently incompatible with the liquidation process under the code, which envisages that a liquidation order is passed will result in dissolution of the corporate debt. Where a business of corporate debt is still viable, the liquidator would have recourse to a going concern sale of business to ensure that the liquidator process remains value maximizing. So this is what the entire recommendation of the committee about the scheme. So finally, how they concluded, given the incompatibility of the scheme of arrangement and the liquidation process, the committee recommended that recourse to section 230 of the Companies Act for effecting scheme of arrangement compromise should not be available during liquidation of the corporate data under the code. However, committee felt that appropriate process to allow the liquidator to effect compromise or settlement with specific creditor should be devised under the code. That means what the committee recommends that it is not advisable simply borrow from Companies Act and making liquidator to follow that. Then it becomes all the more difficult, impracticable, time delay, and everything is coming. Rather, what committee suggests is that to allow liquidator to effect a compromise settlement with a specific creditor, how it should be devised under the code. That means it should be a separate, like how there is a regulation for liquidation CRP. Similar way, probably they may be suggesting a regulation separately for the scheme, how to devise it, how to properly make it. That's what I could understand from the committee report regarding the scheme, how to contemplate the scheme and how to take it forward the compromise scheme during the liquidation after the liquidation is ordered. So hope now you must be having whatever the doubts in your mind about the scheme of compromise, because scheme of compromise also is nothing but a sale of corporate data as a going concern, right? Though the word not used as a sale, it is used as acquisition. So it is nothing but an acquisition of corporate data as an ongoing concern basis. In liquidation, we are calling it as sale. So, so now I think you must be in a position to appreciate what originally went on to the minds of Honorable Appellate Authority, then how it got amended in the regulation, then how the committee in the report, the February 2020 report, they viewed it and they observed it, they recommended it. But it's yet to come into effect or yet to give into effect. Probably IBB may be working on it. Probably this suggestion may be given to our AIP to recommend. If there's a separate process is prescribed for the scheme that is to be contemplated under IBC, then that would be better. Read with the provisions of Companies Act.
So I think after hearing or seeing all this, which is there in the report, it is very strange that the amendment has taken place and the regulation, very strange, because the committee report is very, very clear on this.
Yeah, very strange. Yes.
It's only going back and forth on a topic, and then the entire concept, underlying principle of IBC is that there has to be a minimal time lost so that value destruction is kept to the minimum. Now going back after CIP, once you are in liquidation to a scheme of arrangement with all the incompatibilities, I think it's like putting somebody on a ventilator and then trying to do something again without a ventilator and coming back to the ventilator. I think it's a very strange thing that has happened, that IBBI has come up with the amended regulation the way it has.
See, in one line, if I have to, what I understand from the this report is they are trying to say that why you keep repeating the same process now and then and saying time-bound process, but you are repeating the same process.
We are trying to go back and forth. Once
Yeah,
it is decided the company has no value, once the CIP has failed, only then the liquidation has been ordered. Then why are we trying to get back to section 230 of the Companies Act for a scheme? It has to be something independent. There can be a buyer who comes up with a proposal, and that proposal can be to buy a company, and that can be considered. But it cannot be more than that. You can't be going back to section 230 of the Companies Act in liquidation. And all the reasons which are given in the committee report are very, very clear. I think a strong representation needs to go from the IPA so that the matter is correctly considered in proper perspective by IBBI.
Yes, sir. You are right. Because the committee has made it very clear. They made it very clear because after applying their mind and after observing what has happened, they made it very clear, no doubt. Now it's only left with the authority, regulatory authority, IBBA, to work on it, to see that how this a set of principle, procedure, process has been introduced specifically for the purpose of contemplating a scheme. Okay. So can we take a small break, 5-10 minutes? Then move on to sale of going concern?
Sir, we can take a break.
Yes, ma'am. Thank you. Thanks a lot, ma'am. Can we start? Yeah, I'll share the screen again. Yes. Yeah, now we were seeing committee report. Yeah. So now we will move on to the going concern sale during liquidation. Okay. So now at least now, I thought I can deliberate little because we are into the main topic of going concern. Okay. Can I take the inputs of the participants? Can you tell me the going concern? What are the provisions? What are the provisions? Are except 32, is there any other provision? I'll put it this way, except regulation 32. Is there any other provision under IBC for going concern sale? Say any other provision except 32. I can even show you the 32 also. Because we are going to deliberate more on the sale of going concern and now before that we should know what is there in code on going concern. Okay, sale of assets going concern. Just a moment. Yeah, see the liquidator may sell assets on standalone basis, lump sum sale, a set of assets collectively, the assets in parcel, corporate debtor as a going concern. So 32E, this only talks about corporate debtor as a going concern. Then business of the corporate debtor as a going concern. So F, 32F. Okay. Now, liquidator may sell. Okay, it is an option given. So this is the only provision. And 32A talks about sale as a going concern. Where it says that where the committee of creditor has recommended the sale under E or F. That means before company goes into liquidation or before filing the application for liquidation, in the last meeting, the committee has to recommend. That's what we have to understand. Regulation 32A. Okay. The committee of creditor has recommended the sale under E or F of regulation 32, or where the liquidator is of the opinion that sale under class E or F of regulation 32 shall maximize the value of corporate debtor. He shall endeavor to first sell under the said class. That means if the liquidator is of the opinion that sale under E and F shall maximize, then that means there's a two things. One is where committee is recommended, one. Two, where liquidator is of the opinion that sale under class E and F shall maximize, then he shall endeavor to sell. First sell that under that classes only. Okay. For the purpose of sale under regulation 1, the group of assets and liability of the corporate debtor as identified by the committee of creditor under subregulation 2 of regulation 39C of IBC regulation shall be sold as a going concern, has to be identified for the purpose of regulation 1. Group of assets and liability of the corporate debtor, okay, as identified by the committee under subregulation 2 of the 39C. Okay, this is one provision. There is another provision where the committee of creditor has not identified. Suppose the committee of creditor has not identified the assets and liabilities under regulation 2 of regulation 39C of insolvency process, corporate person. Okay, then liquidator shall identify the group of assets and liability to be sold as a going concern in consultation with the consultation committee. So this is what the provision on sale as a going concern. The liquidator may sell the assets of the corporate debtor under Class E of regulation exclusively only at the first E option, first action. That means this is introduced recently. Okay, this is introduced only in the September 2022. This last provision alone. Okay, this is only introduced in September 2022 that liquidator can sell the sale of assets of the corporate debtor. Liquidator may sell the assets of the corporate debtor under Class E of the regulation exclusively only at the first action. Okay. Now, one is in the first action, the liquidator has to sell. After that, he should not try at all selling the assets under E. E is what? Going concern. E is the corporate debtor as a going concern. Here, my question comes here. Here, E says corporate debtor as a whole as a going concern. Here, the amendment which has been brought in, this here says, this amendment, recent amendment says, liquidator may sell the assets of the corporate debtor under Class C of the regulation 32E. So, this talks about assets of corporate debtor under Class C. This talks about corporate debtor as a going concern. Can you please give your inputs? What exactly, whether the assets of the corporate debtor or corporate debtor as a going concern? Because the same regulation which enable the liquidator to sell corporate debtor itself as a going concern under Class D. Whereas now, by virtue of a recent amendment, it has been introduced as a subclass 4 of 32A, wherein it says liquidator may sell the assets of corporate debtor under Class E. Means it is not the corporate debtor under Class E. Okay. It says assets of the corporate debtor under Class C. That means, can we say that under Class C corporate debtor, it can be sold as a corporate debtor, it can be sold as assets of corporate debtor? Both are possible. One, whether could be understood that way, whether sale of assets of the corporate debtor itself will be deemed as a corporate debtor as a going concern. How it should be understood? Any view of the participants? Because here we are going to deal with this situation. See, if you are practicing IP, for sure you will be encountering this situation. We should have a clarity. Okay, at least under Class 32F, it is very clear. Business of the corporate debtor as a going concern. It talks about business of corporate debtor. Okay. But Class E talks about corporate debtor as a going concern. But here 32A, it says very clearly assets of the corporate debtor under Class E of regulation 32. But Class E of 32 talks about corporate debtor as a whole. As a going concern, not the assets of the corporate debtor. So, what kind of interpretation should be given? Or what should be the real intention of the regulator, to do, liquidator to do, whether to sell assets of corporate debtor or whether to sell the corporate debtor as a going concern? Any experience you come across any such situation? Do you have any experience doing sale of corporate debtor as a going concern? That means what they deem by corporate debtor, sale of corporate debtor as a going concern is they deem it as a sale of assets of corporate debtor as a going concern. Both are one and the same or both are different? If both are different, in what sense? Whether Class E has got two different bifurcation, division, whether can it be deemed that way? And how should be interpreted? We have to understand, sale of corporate debtor as a going concern. So we have to see that how the language has to be understood to put it in practice. To put it in practice, we should know what exactly the law provides for. Then only we can put it in practice. So you are okay. So mode of sale, you all know that here it doesn't talk about going concern and doesn't deal with it as a going concern. Again, if you see in valuation, it's very important to see in valuation. Why it is important? Because by virtue of an amendment, okay, amendment by virtue of a notification of the IBBA 25th July 2019, okay, it has been brought in, whereby in cases not covered under Regulation 1, or where Liquidity is of opinion that a fresh valuation is required under the E share within 7 days of commencement date, appoint two register value to determine. Very important to note, to determine the realizable value of the assets or businesses under class A to F of Regulation 32 of the Corp Debt. That means the valuation itself has to be done. Valuation itself has to be done by the register valuer. How? It should be done an asset on a standalone basis. Valuation to be done as assets in lump sum sale. Valuation to be done as a set of assets collectively. Valuation to be assets in parcel. Valuation to be done corporate as going concern. Valuation to be done under business of the corporate as going concern. That means a separate valuation has to be done in all these methods because it is made mandatory under Regulation 35 that valuation has to be done pursuant to Regulation 32A to F. Okay. Here also the corporate debtor should be valued as a corporate debtor as a going concern. Okay. Now, anyway, I'm not getting any inputs from you. Better I will move on to whatever I wanted to say. Now, if you see, all this is only a consultation committee formation. I wanted you to take you through now to the committee report. Okay, now I showed you what is in the regulation. Now you know what is in the regulation under liquidation. Okay, now what the committee feels and what the committee gives in the report. Now one more regulation I have to show you, which is relevant, going concern, which is relevant. Which is relevant for the going concern sale. That's what I was asking your input. So since you kept quiet, I'm giving all this 39, 36A, B. Yeah. Preservation of records, liquidation cost. Okay. Now, so this is another important thing. There was an amendment in CRP regulation with regard to the compromise arrangement, as also there's an insertion of assessment of sale as a going concern in the CRP. Okay. This with regard to assessment of compromise arrangement, this has been inserted recently wide notification of IBBA dated 16th September 2022. This has been inserted. Okay. What in this? While deciding to liquidate the corporate debtor under 33, section 33, the committee shall examine whether to explore. See, this is very important. This is a recent amendment. Okay. Going forward, everyone will encounter this when we have it. While deciding to liquidate the corporate debtor under section 33, the committee shall examine. So now they made it as a mandatory on part of the committee. Shall examine whether to explore compromise or arrangement as referred in subsection Regulation 1 of regulation 2B, which I showed you, liquidation regulation. Okay. Regulation, subsection 1 of regulation 2B of IBBA liquidation regulation 2016. And the resolution professional shall submit the RP because it is during CRP. Okay. The RP shall submit the committee's recommendations to the adjudicating authority while filing application under section 33. That means one more thing. Suggestion itself is now has to be filed. The recommendation of the committee itself with regard to the assessment of compromise arrangement. That means how far it is suitable after exploring CARP, after finishing the process of CRP, exploring the possibility of sale of going concern, acquiring as going concern through a resolution plan. Now again, committee is given a responsibility to examine whether to explore compromise arrangement as referred under subregulation 1 of regulation 2B of liquidation regulation. So it is now the RP is duty bound to file a liquidation application along with the committee's recommendation to the adjudicating authority while filing the application under section 23 with respect to committee's recommendation on assessment of the compromise arrangement. Okay. Now, if recommendation is made under regulation 1, the RPN committee shall keep exploring the possibility of compromise arrangement during the period the application to liquidate the corporator is pending to adjudicate. Now, it is not that earlier liquidator after filing a liquidation application he will be waiting. Okay, till liquidation order comes, he can't do anything because once the application is moved to the adjudicating authority, then after that he may not be permitted to do things under CRP, neither under CRP nor under liquidation. So why to waste that particular breathing time gap? So now the amendment put in place, the amendment came into place, wherein it said, whatever the recommendation given, which is filed before the adjudicating authority, that recommendation has to be explored by both by the committee as well as the liquidator. So both the RP, resolution of it. That means the RP and committee, even after filing a liquidation application with the adjudicating authority, shall keep the exploring the possibility of compromise arrangement during the period of application to liquidate the corporator. That means if any application comes during pending before the application of liquidation application before an adjudicating authority, in fact, this indirectly says that the RP can receive the scheme when the application is pending before the adjudicating authority for liquidation. Because keep exploring means then we need to invite and we need to get the suppose some application, some scheme is coming in the hands of the liquidator, or committee is bringing some option to liquidator for scheme, then it will become a duty of the liquidator to receive the scheme and keep it ready to file it immediately after the liquidation is ordered. That must be the reason where the date of filing of application under section 33 for liquidation and date of order of adjudicating authority ordering liquidation. This in between time, as per the regulation, should be used by the committee as well as RP in exploring the possibility of compromise and arrangement. So it should be important to note that RP and committee cannot keep quiet after filing application of liquidation.
So a question at this stage, practically how will the liquidator form a committee? Who will be the members of the committee of creditors? How will it work? And then what is the role of the committee as distinct from the consultation committee? How will it practically work?
See, till liquidation is ordered, company is not in liquidation, right? Till liquidation is ordered, because it says application to liquidate of the CD is pending before AA. That means before order of liquidation. till the liquidation order comes, company CD is not in liquidation. Okay. That means the RP before the order of liquidation passed by AA, the RP and committee. It is open to RP and committee to get the scheme or compromise arrangement and keep ready for.
My question is, who will be the members of the committee and how will that committee work? Committee of creditors?
Same they say committee is nothing but in CRP, whatever the committee, that committee only they refer. There is no separate committee for that. They refer only that committee, the resolution professional and the committee. That means the committee which is there in the CRP. Because the company has not ordered for liquidation. Till liquidation is ordered, what are the role rendered by the RP and committee? Stand extended till the order of liquidation. So they should receive a scheme. Suppose any scheme of arrangement or compromise has come in the hands of the liquidator, or through committee, the scheme come in the hands of the liquidator. The liquidator should see that immediately is filing, because there is a time of 30 days time is given to liquidator. Because he has to study the scheme, he has to see that what is right and wrong, and legally it is right or wrong, whether it meet with the requirement of the provisions, all that he has to see and keep it ready for filing within 30 days. Because the provision only says 30 days time, regulation 2B. Correct?
I don't know. Not a question which I've understood, because you see, you're talking about timelines. The way I practically see which can happen, first of all, it's very strange, as I expressed before, that Section 230 is coming into place after liquidation order. That's okay. But once the liquidator has to form a committee of creditors, that can be formed only of the creditors from whom the claims have been received. And then that committee of creditors will be including both operational and financial creditors. Third, if Section 230 voting, etc., has to be gone through, is the entire set of creditors, operational and financial, who will vote. That's the way I see it. And then there is a consultation committee which had a consultation role, which will be quite independent of this committee. So I think it's like, that's the only practical approach that I see if this regulation has to be followed and if this regulation is not corrected. So I don't know what your thoughts are on this.
See, yeah, see, I'm taking your point. See, here what they are trying to do is, they are literally slowly, they are giving a rope to the scheme. Because earlier there was only one provision in 2B in liquidation. Okay, earlier there's only one provision. There was no other provision under the liquidation regulation. There's only one provision. Now in CRP they amended to bring this provision, which I now just read out. Okay. Now what you are referring that there's a committee of creditor during CRP, and after liquidation, you all know that the liquidator has to form a stakeholder consultation committee, that ACC we call. It is so during CRP there's a committee of creditor, and during liquidation there's a ACC committee. Okay. In between, the regulation does not provide any other committee. So now we have to presume only whatever the court says. We have to presume that when we read the language of it, okay, where a recommendation has been made under regulation 1, that means it is a continuation of regulation 1. If you read the regulation 1, while deciding to liquidate the corporate debtor under 33, who will decide liquidate the corporate debtor? Only the existing committee of creditors only can decide. That means whatever this regulation 2, subregulation 2 talks about committee is nothing but a committee of creditor, because it only gives a responsibility to the committee of creditors who is deciding the liquidation, not otherwise. no other committee or no other person is involved. Because if you read the language, subsection 1, subregulation 1 and regulation 2. Regulation 2, subregulation 2 is a continuation of subregulation 1. So the subregulation 2 starts where a recommendation has been made under subregulation 1. Subregulation 1 says while deciding to liquidate the corporate debtor. That means it's making very clear that it's a committee of creditor, which is there in the CRT. They have to keep exploring possibility of compromise and arrangement. How to keep exploring? Whether they can give invitation, the law is silent on that. Then what keep exploring? Probably if they get any scheme in hand. Earlier they may not be permitted to receive it. Now because of this provision, they may be permitted to receive it. The liquidator or committee of creditor, now they are, even during the application under section 33 is pending before the adjudicating authority for ordering liquidation. Even during that time, now committee as well as the liquidator is given a free hand to receive a scheme of compromise arrangement and file it as soon as the order of liquidation as given by the adjudicating authority. That's what is sound. I don't think you have any other, still you have any other point to deliberate. There is no answer for many things. I'm just telling what is there in the regulation. Rest of the things differs case by case. One has to explore. They have to get into the case and see that what kind of direction they are getting from adjudicating authority, implement it, see the replication, then again run to the adjudicating authority, get the order, implement, see the replication, then run to the adjudicating authority. That's how things are getting implemented. Hope you will also agree. Okay. So this is a new provision which has come. Okay. Now they want to utilize and make use of the time gap between filing the application of under section 33 for liquidation and order of adjudicating authority passing liquidation under section 33. This time gap also they are giving a response. The code is giving, means the regulation giving a responsibility both to the committee as well as the liquidator to keep exploring the possibility of getting the scheme. Okay. Now coming to 39C. Now what we have seen is 39BA. B is a meeting of liquidation cost. It's BA, introduces a BA, which we have seen now. Coming to 39C. What 39C? Assessment of sale as a going concern. This is a CRP regulation. Now, while approving a resolution plan under section 30 or deciding to liquidate the CD under 33, the committee may recommend that the liquidator may first explore sale of corporate debtor as a going concern. Please note here also sale of corporate debtor, but there I was showing a point where it says sale of assets of the corporate debtor going concern under class E. First, they should explore first sale of assets. There's a clear difference between these two. That only I was asking you, what is your viewpoint on that? Here I showed you, you just see the difference, no? The language, which is very important. 32A, the last one. Liquidators may sell the assets of corporate under class E of regulation 32 exclusively only as the first action. Exclusively only at the first action. Okay. Now come to see, please note here, this is assets of the corporate debtor in the first E action, class E of regulation 32. Okay. Now come to CRP. Coming to CRP, same language. First explore sale of a corporate debtor, not assets of the corporate debtor. There in liquidation regulation we have seen, first he has to ensure first time only of sale of assets of the corporate data as a going concern under class E, same class E, under 32. Class E talks about corporate data as a going concern, sale of corporate data as a going concern. E. But here, if you see CRP, here it talks about sale of corporate data as a going concern under class E of regulation, class E of regulation 32 of IBBA, liquidation process regulation. That's what I was referring to you, how to take it, how to understand whether sale of assets of a corporate data as a going concern is permitted as provided in the 32A of liquidation regulation, or sale of corporate data as a going concern, which the liquidator has to do. That we have to understand first. I think that we have to come on, they have to come out with a clarification or to make it clear that what exactly the liquidator has to do under class E of 32. Or sale of business of a corporate data as a going concern class F. Here, I think, okay, same language is that sale of corporate business of the corporate data. Okay, same class F, sale of business only is there. Okay. So while approving the plan or designing liquidator, the committee may recommend. So it is only may recommend that liquidator may first explore. Here both are may only. So that means it is only an option given. May. Whereas in the liquidation regulation, the liquidator may sell the thing is may. That means in first action, it is not mandatory. Is it not mandatory on part of liquidator to sell the corporate data under class E? No, the E may. So that means if we feel there's asset maximization, that E may sell. That's what the see where the liquidator is of the opinion that sale under E, here F is added, but E alone is there. Okay, there. Shall maximize the value of corporate data, he shall endeavor to first sell the under class A classes. Here, class E. Okay, at the first E action, sell the assets of corporate data. So here also it's may. It's not, that means it is not mandatory on part of the liquidator that assets should be sold as a going concern in the first instance. But the liquidator is given a free hand if in his opinion, if he sees that that will maximize the asset value, in the first T action alone, he can sell the assets of the corporate debtor under class E of regulation. But class E of regulation 32 talks about corporate debtor as a going concern. But here it says assets of corporate debtor. We have to wait for the clarification to come. Okay. Now, point number 2, that means regulations are sub-regulation 2 of regulation 13 C, CARP regulation, where the committee recommends sale as a going concern. It shall identify and group the assets and liability, which according to its commercial consideration ought to be sold as a going concern under class E, class F of regulation 32 of IBBA liquidation regulation. That means if the committee recommends sale as a going concern, it shall identify. There is no option given. It shall identify and group the assets and liability, which according to the commercial consideration ought to be sold as a going concern under. Okay. So now it is a responsibility given to the committee. If they recommend sale as a going concern, they have to identify the group of assets and liability, which according to them ought to be sold as a going concern. That means here this particular paragraph, when we read the language of it, when it says shall identify the group of assets and liability means, that means as a division. It's not that the entire asset, I think corporate data, even a division can be identified, because identify and group the assets liability. So they can identify and group that particular assets and liability, which can be sold as a going concern. So that means the going concern need not to be sale, need not to be corporate debtor as a whole. The going concern sale can also be assets and liability identified by COC can be sold as a going concern under class E or class F in both the scenario. Again, class E and class F CARP. Again, the confusion is that same thing which I keep showing you. Regulation 32 sale of assets talks corporate debtor as a going concern. Here it does not say assets of corporate debtor going concern. But if you see the regulation, CRP regulation, if you see the CRP regulation, it says identify the group of assets and liability ought to be sold as a going concern under class E. That means class E itself getting bifurcated in different fashion. I think we have to wait and see how the clarification comes from IBA and how to deal with the class E. Because class F, okay, since the business can be sold as a going concern, a group of assets and liability can be identified which is associated to the business under class F of 32. Right? There it can be identified and it can be grouped. Assets and liability can be grouped for sale of the business of the corporate debtor under regulation 32, because class F of regulation 32 of liquidation regulation, it permits, see, liquidation regulation, business of the corporate debtor as a going concern. So this here, there is no confusion. So a group of assets and liability can be ascertained, identified, can be sold under class F of regulation 32 as business. Whereas in case of class E, we have to wait and see whether the regulation permits the liquidator to sell the assets of corporate debtor as a going concern. Then can the assets be sold as a going concern? The next question comes, whether the assets can be sold as a going concern. How? Land and building and machinery can be sold as a going concern. Then what is, then that's what the first question I had raised before, commencing my session. The first question I was putting to you as a participant, I wanted to hear from you, what is going concern? Why I put that question is for this reason. Because business can be given as a going concern, corporate debtor can be given as a going concern. As per these regulations which we discussed, deliberated, assets of the corporate debtor also can be sold as a going concern. So what is that? Assets of the corporate debtor can be sold as a going concern. How the assets can be given as a going concern? Assets can be given in a running condition, right? Any inputs? You are here only to listen 3 hours and switch off, not to share any of your inputs. You want to keep it everything secret, all your experiences. You don't want to share anything. Yeah, you have to encounter the situation, as a liquidator, as a RP and liquidator. We all should encounter the situation. We have to have a clarity on this, how to deal with when situation comes, or if situation already is there, how to deal with that. Can the asset can be sold as a going concern? Can I have your views? Can assets alone can be sold as a going concern? What is that assets as a going concern? Any inputs? Or do you have any other thought process that asset can be sold as a going concern? Not the corporate debtor, assets of the corporate debtor. Okay. So you are telling when situation comes, that time you will see. Now let us not too much break our head, right? I leave it to you. I will also leave it as it is, because it's ultimately everyone we have to deliberate and understand this. Actually, there's not, my view is not going to help you in any way, because there is no any evidence for, even if I share something that to show that yes, this particular situation or this particular asset can be sold as a going concern. how the assets can be sold as a going concern. Asset can be given in a running condition. Asset can be given in a good condition. The asset can be sold as a going concern. Okay. Probably the
No,
division.
normally when the going concern is sold, all assets and assets are assumed to be sold along with it.
Correct. Here, when sale of corporate debtor is sold as a going concern, that means if the corporate debtor sold as a going concern, I understand along with the corporate debtor, asset is by default sold as a
Will
going.
go. Yes.
There is no confusion on that aspects. Confusion is only that corporate data is not sold, the assets of corporate data is sold. Because the regulation says only the assets of corporate data, not the corporate data per se. That's what I showed you also. In liquidation regulation, I showed you in liquidation regulation, here 32A, here it says sell the assets of corporate under class E of regulation 32. What regulation 32E says? Corporate data as a going concern, not assets of corporate data. So you see now CRP regulation. Here again it says identify group the assets which ought to be sold as a going concern under class E. If class X, okay, we can understand, okay, business, when it is sold along with the respective division, whatever the assets are liability in the respective division can be sold along with the business. Business is nothing but it's comprising of assets and liability. We can try to understand that way. But class E, the regulation 3 say 32 class E says corporate data is a going concern. But here why they have to say assets of corporate data? That means both are one and the same.
There seems to be some contradictions within the board.
So, right. Then I will move on to next one. Regulation, sub-regulation 3. Resolution professional shall submit the recommendation of the committee under regulation sub-regulation 1 and 2 to the AA while filing the approval or decision of the committee. This we read there itself. So it is now duty to file. No, while filing the application itself, now the RP is given responsibility of giving the recommendation of the committee, where we have seen in the scheme, same provision is there for going concern also. Scheme we have seen. See, resolution professional shall submit the committee recommendation. Here the recommendation is that to explore the scheme of arrangement. Here for scheme we have seen. Now here this talks about the RP shall submit recommendation of committee under 1 and 2. That means sale as a corporate debtor, that itself. Suppose that means the committee is given a responsibility of exploring whether scheme, what is the option available for the scheme? Whether sale of assets of the corporate debtor, what is the option available? Sale of assets or sale of corporate debtor under liquidation 32. Or the committee again should give a recommendation on class F. That means sale of business as a going concern. So 3 recommendations the committee can give to the resolution professional. And along with that recommendation, the RP has to file the application before. So that means the RP cannot simply file an application under section 33 of the IBC code just for liquidation. The RP along with the liquidation application should file the recommendation of the COC on scheme, explore a scheme option, exploring sale of going concern, assets of the corporate data as a going concern option, sale of the business as a going concern option. Along with the application, liquidation application, the recommendation of committee also should be filed. It is mandatory. When the recommendation given, then along with the recommendation only it should be filed. So it is mandatory. Now coming to the report, now it's very important. Yeah. So here this I showed you already. Okay. happening? Why it is not showing? Again, we'll go here. Okay, fine. It is here. Correct. Okay. Now I want you to take you through a few minutes. Then I will run my PPT quickly and I will explain you and I will run my PPT. I got more than 50, 60 slides, but still, I thought more than explaining how to do, because when the regulation and law itself is silent, how I can say that how to do the going concern sale. So before I'm giving my thought process on going concern sale, how to liquidator as a liquidator that he should render or get endeavor to do a sale of going concern. I wanted to see that what first of all the law permits us. First of all, we should know what the law permits. Then only we can see that accordingly what to go forward. Because if you see orders, there are I can show you all those orders also. Okay, that all orders are given only for that respective corporate debtor. No, that cannot be taken as a order that is given to any company which is under liquidation, which is exploring the scheme option, which is exploring to the sale of corporate debtor as a going concern. That cannot be taken because there are 10 different orders with a different limitations and provisions and conditions by different benches. So that cannot be taken and applied to our case. Whatever suits to us, we can't apply. No, that means we have to get a clarity by filing a necessary application to the adjudicating authority to suit whatever input that we need to render the role of liquidator while doing sale of going concern. So better to have a law in place so that the liquidator need not to in dark, to confuse what to do, how to deal with that, what is the process in place. Okay, let's take you through next 5 minutes this committee report. This, as I was telling, this is insolvency law committee report. If you see the committee report, it says going concern served during liquidation. What the committee says in 2020, Regulation 32 of liquidation regulation permits a liquidator to sell a CD or its business as a going concern. Okay, because 32 permits. Committee deliberated whether liquidator should be mandated to conduct a going concern sale by order of adjudicating authority. This is the first question. Okay. Further, it was also discussed whether a going concern sale of corporate debtor itself should be permissible during liquidation. My God, the question is put like this: whether that itself can be permitted, though regulation is there. Again, they are reviewing. They want to review the regulation itself, whether going concern sale of the corporate debtor itself should be permissible during the liquidation. Okay. Then again, they are telling, as discussed above, liquidator may choose to liquidate the corporate debtor by selling the business on a going concern basis. Regulation 13C of CRP regulation also permits the COC to recommend such a sale during CRP because business can be sold as a going concern. Okay. In addition to this appellate authority, I showed you the order, appellate authority and appellate order, as in certain cases ordered that during the liquidation process, steps required to be taken for revival and continuation of corporate debtor by protecting the corporate debtor from its management and from a debt of liquidity. Thus, the steps which are required to be taken, all three, which I read also in the order itself, I read. Receiving compromise arrangement from creditor, class of creditor, member under 230. On failure, liquidator is required to take steps to sell the business of the corporate debtor as going concern in totality along with the employees. The last stage will be death of the corporate debtor by liquidation. Okay. So now the liquidator has been mandated to attempt a going concern sale of business of corporate debtor prior to disposing the assets of corporate debtor in any other manner. Okay. This has given rise to a concern that valuable time may be lost in attempting such a sale in cases where it would be commercially prudent to expediently liquidate the corporate debtor on a piecemeal basis. Okay. While noting that going concern sale of the business of a corporate debtor has certain advantages over other modes of liquidation, such as preservation of employment, Committee agreed. Committee means the insolvency law committee. Agreed that it may not be possible, may not be a feasible option for every corporate debtor undergoing liquidation. So it says it is not possible for every corporate debtor. Where the business of corporate debtor is found to be economically unviable, attempting a going concern sale would be value destructive. Further, in cases where there is a lack of adequate finance to run the operation of corporate debtor during liquidation process, a going concern sale may not be possible. That's why I would put the question to participants earlier in the beginning of the session that whether is it a prerequisite that corporate debtor should be on a going concern, should be in a running condition to endeavor sale of corporate debtor as a going concern by the liquidator. Because here the committee report, they say that it is not possible in cases where there's a lack of adequate finance to run the operation of corporate debtor during liquidation process. Going concern, how it can be sold. That means that company cannot be sold as a going concern when it is not in a running condition for want of fund. So not possible. So further, the committee has observed, noted that liquidator is best placed to decide whether going concern sale should be attempted after assessing relevant factor, commercial viability of the business, consulting relevant stakeholder, in order to ensure that it would generate greater value than the other modes of liquidation. While taking this decision, liquidator may consult stakeholder committee, being able may assist the liquidator in evaluating the commercial present. If the COC is of the opinion that the going concern sale would be most value maximizing option during liquidation, it may recommend that to the liquidator should attempt a going concern sale. Additionally, as a fee of liquidator in some cases linked to the total amount released, liquidator is incentivized to choose the most value maximizing mode of liquidation. So here, if you see, given this, committee agreed that going concern sale should not be mandated during liquidation, and that the liquidator is in consultation with the relevant stakeholder should be permitted to decide if a going concern sale should be attempted or not. That means the committee says that it should be left to the liquidator and the SEC consultation committee to decide whether it should be sold as a going concern. So it should not be put as a condition during the liquidation. That's what the condition, whether in the code or whether by an order. That's what the committee's observation. Okay. Going concern sale of a corporate debtor. So regulation 32 permits the liquidator to attempt a going concern of a corporate debtor, as well as this implies the entity may also be revived, not to be dissolved, an outcome of liquidation. In the light of this, committee discussed whether liquidator should be permitted to sell the corporate itself during liquidation as a going. The court provides a linear process for resolving, during which COC assesses the viability. Only when the CRP fails, the court provides for an entry into liquidation. Thus, liquidation has been envisaged as the state of entity enters at the end of an IRP, where neither creditor nor debtor can find commonly agreeable solution by which to keep the entity as a going concern. Therefore, entry into liquidation itself implies inability of the corporate debtor to be continued as a going concern. Then where is the question of going concern? That's what they are raising. Accordingly, the court prescribed dissolution of corporate debtor as a final outcome. That's why the court says, as a final outcome, the corporate debtor should be dissolved. Because the moment it enters into liquidation, where is the question of going concern? Because already explored all the options. After exploring option only, it has come to the stage of liquidation. Where is the question of again exploring revival? That's what the committee has given a observation points. Committee also noted that attempts to revive a company after an opinion for liquidation was issued by BFR or winding up was ordered under Companies Act was considered as a source of value destruction delays. Committee noted that if attempt for reviving the corporate debtor are undertaken after liquidation order is passed, it may lead to delay and may also undermine the efficacy of the CRP. That means the CRP allowance is going away. That's what their observation. That means then why the CRP? Then anyway you are trying during liquidation also. Same thing. Then what is the allowance of CRP? Why significance of CRP? That's what they are trying to say. Which provides time bound period for reviewing the corporate data. So we are saying time bound 330 days time. Then again we are giving the same option for revival. Then why is the fundamental is intact here? Whereas the time bound is there? Because it is going beyond time also we are permitting same revival. We are exploring same revival. Beyond that. That means it is not falling within the parameter of code. That's what they are observing. For this purpose, section 11D of the code prohibits corporate data undergoing liquidation from reinitiating CRP. That's why they are saying it is prohibiting reinitiating. So in the light of the above, the committee agreed that it would be contrary to the scheme of the code. Repeat again, I'm reading it. The committee agreed that, the insolvency committee agreed that it would be contrary to the scheme of the code to allow corporate data to be sold as a going concern after conclusion of its liquidation process, which envisages a dissolution of the corporate entity. However, where the business of a corporate debtor can be sold as a going concern, the liquidator may attempt the same. Accordingly, the liquidation regulation should be appropriately amended to prevent a going concern sale of a corporate debtor. That's what the committee recommended. This is the committee recommendation on going concern.
So is not this recommendation contrary to the regulation, sir?
I
Because
don't-
the regulation recognizes even sale as a going concern, liquidation as a going concern.
No, sir, this is there as a committee's recommendation. I thought if I don't refer this, we won't be complete in our discussion, right? But just by seeing the regulation, if we conclude. So what makes that regulation to come, or what has gone in the minds of regulator to bring the regulation? For that, we need to see the committee report only. No? That's why I thought, okay, let's go through the committee report. So I placed it before you the points of the committee report. But unfortunately, the question what you asked, I literally, I don't know whether probably IBBA are in the stage of implementation, or what is the process involved in that we may not be knowing, because it's only a regulatory process which has to be followed by the IBBA after getting the report. So we have to wait and see the days to come. What are the amendments are? So what I'm trying to say here, end of the day, these are the views, okay, that one can understand. These are the points that one has to understand, okay, before getting into the process. Of course, there is a regulation in place. We are obligated to follow the regulation, and we have to go by the regulation. But these are the points that are, given as a suggestions by the committee to the regulators. Probably regulator may be in the process to review it. Otherwise, the institutions like our IAC, SAIP, or other institutions, they should also can escalate and see that wherever clarity is required in the regulation, they can request the IBBA to bring out the clarity. But these are the provisions which is provided as a recommendation of the committee with regard to going concern sale. Now coming to the PPT, Sunday I was telling you, sale of corporate debtor as a going concern. So here, why I have not started with my PPT is that I wanted you to understand, including me, whether you or me, we need to understand what exactly the entire dimension. See, all are dimensions only. See, we may have a different view of any law, leave at all this IBC law, any law for this matter in our country. we'll have a different view. But the lawmakers and regulators, they have their own reason for bringing a law into the force. Okay, so we have to find out what is the reason behind it, rationale behind it. Probably there must be some reason and rationale, due to which the regulators would have brought the provision. Now, if suppose the situation demand, circumstances demand, our representation comes more from professionals and other stakeholders, then again the regulator has to review, they will review when they get it. So probably we'll see how it can be, representation can be given. Now, now we have seen deliberated a sale as a going concern in various aspects. We have seen the regulations, and we have seen in the committee report. Okay, of course, a few cases also I will show you. But what exactly is the sale of as a going concern? If one has to understand generally, I'm saying, it's related. You all know that it's a new concept. Can you tell me the entire insolvency bankruptcy code whether sale as a going concern word is there? Going concern is there. During CRP, the corporate data should be kept as a going concern, it is there. But entire insolvency bankruptcy code, is there any concept sale as a going concern is recognized in the code? It is recognized by the regulation, whether it is there in the code. Okay, so probably the amendment may require future to bring it in the code to bring more clarity. Okay, that's why by way of amendment, regulation 32 has been amended to bring it sale as a going concern. Instead of amending the code, they amended the regulation. Okay, going concern sale under liquidation, it's mainly focusing selling of assets for the maximum value. Okay, not necessarily killing the entity, then do. So statute might provide for liquidation of the entity as a last resort, but sale of going concern that really relieves, okay, the corporate data from the stress of killing it. Okay, selling of corporate data as a going concern means sale of a business of corporate data along with its assets and profit, to enable to keep the value of the corporate data even during the process of liquidation. What are the assets are transferred? The going concern sale in liquidation is concerned. There's a clear difference that only the assets are transferred. The liability of corporate data has to be settled in accordance with the 53 of the code. Because if the liability also gets transferred, there's no purpose is achieved by bringing the code, a complete code like insolvency code. Because the fundamental of the code itself to address the liability, to address the financial failure, how to revive it and settle it. Okay. So if the liability also has to be transferred, then the purpose of the code itself may not be achieved, because the solution, the stakeholder will not get any solution, because the heart of the entire IBC is section 53. Okay, how much the stakeholder gets their share distribution. That only decides, relieves the entire corporate data or asset or the business of the corporate data completely. It relieves the entire corporate data from the earlier burden, because with the distribution to the stakeholder under section 53 of the code, it should relieve everything. That's the basic fundamentals and understanding of the code. If that also continues, then the fundamental itself is not getting taken care of. So hence the purchaser of this assets takeover without any incumbent, that's the basic ideology. Okay. Now if you see going concern sale during the corporate insolvency resolution. The procedure of going concern sale is that during the CRP, the creditor required to identify, which I showed you, regulation 36C, I showed you, where it clearly says what needs to be. CRP regulation very clearly said that they have to identify the group of assets and liability along with the business to sell it. Okay, the same is done by the for the liquidator to consider if the corporate debtor enters into liquidation. If the creditor fails to identify, the liquidator must identify, also the liquidator must first attempt sale as a going concern within 19 days of the commencement. That means exploring the scheme process. Advantage of sale as of going concern. The going concern, corporate as a whole is transferred. The purchaser gets to run the business of the corporator after sale of the assets of the going concern. The existing employee are usually not fired. They will be retained, if it is a going concern. Can continue their job. The equity shareholding will be transferred instead of part sale and new shares are issued. What is the legality of that? What is the legality of sale of going concern under INB code? So legality is nothing but class F of section 1 of section 35 in the INB code. INB code, it provides is give the powers to the liquidator subject to the direction of the AA adjudicating authority to sell the property of the corporator. Liquidation either by public action or private contract with the power to transfer such property to any other person or body corporate to sell the property in parcel. Okay. Now, Regulation 32 of the liquidation regulation, which we deliberated, I also explained to you, also provides an option to the liquidator to sell the corporate as a going concern or the business of corporate as a going concern. And other options have been provided in the regulation, such as sale of a standalone, all that I showed you in Regulation 32. Okay. Who is deciding sale of going concern? Amendments, as I was referring you, there was an amendment introduced in the liquidation process, which inserted 32A, which allows the stakeholder and the liquidator to take a decision on making a sale on a going concern, which I showed you in the regulation. The same regulation which I showed you also. In case of the committee has recommended, the sale must be made either as a corporate debtor as a going concern 32E or this is a going concern 32F. Our liquidator believes the sale must be done as per the given above mentioned option, then liquidator shall make an endeavor to make sale as per said given classes. So, and the second thing is a group of assets and liability should be identified, which I told you, Regulation 13C. Make it very clear that CRP regulation, there should be group of assets and liability should be identified to be sold as a going. In case committee of data has not identified the assets and liability, the liquidator shall identify as liability to be sold as a going after consultation with the committee of data. If the liquidator has been unable to sell the assets of corporator in accordance with the above mentioned method, and within the 90 days, if we explore the sale scheme option, nothing could be done, then liquidator shall sell the assets according to other methods. Okay. Now, sale of corporate debtor as a going concern 32E. This type of sale of going concern, if you see, corporate debtor is not dissolved. Rather, it forms part of the liquidation estate. It is transferred along with the other business assets and liability, including contract. The consideration will be split into, as you say, I was telling that share capital, what are the money consideration, the new capital can be issued when it is sold as a corporate debtor. Okay. Share will be issued by the corporate debtor and sold to the external share capital. Existing share has to be extinguished. Existing share. The existing shareholder will become a claimant from the process of the section 53. Sale of business, how it can be contemplated. The business of corporate debtor, along with the assets and liability, including its intangible, shall be transferred as a going concern to the acquirer without transfer of corporate debtor. If it is F, 32F, this results in dissolution of corporate debtor. The existing shareholder will be extinguished, and remaining assets which are not sold, part of business will be sold, and sale process derived shall be used to meet the claims under section 53. Here, one important case law which we have to refer. Here, this is the only the case law which I come across that which has been ordered by Honorable NCLAT. Many cases are there. Honorable NCLT has passed many cases on this subject. But Honorable NCLAT held that according to Regulation 32 of IBC regulation, sale of a going concern means sale of both assets and liability and not assets without liabilities. It is concluded that what is concluded is that the sale of going concern means that sale both assets and liability if it is stated that as is where is basis. So this is very important observation given by the Honorable NCLAT. Okay. Now, once it is not sold as a corporate debtor as a going concern, regulation 32E, then the liquidator has to be, the corporate debtor has to be dissolved. Then, according to regulation 45(3)(a), the liquidator shall submit an application along with the final report. Compliance certificate is also to be submitted to AA to close the process, where the corporate debtor will be sold as a going concern. All the assets with the claim and the license, all that will remain with the company. So it is only ownership of the company that is acquired by the, in case of sale as a going concern, corporate debtor as a going concern. Okay, now 47, if you see regulation 47, it provides for timeline. This regulation provides the timeline for completion of liquidation is 1 year, where commencement of liquidation proceeding and appointment of liquidator begins under section 33, 34. Of course, whatever the scheme period of 90 days, it is excluded, which we have seen. This is another important order judgment. Morgan Jameson Jewels Plate Limited through its liquidator. Okay. This order also, it is very important observation is made. The order of adjudicating authority was set aside by the NCLAT, holding that regulation 39C of corporate CRP regulation, related with the regulation 32(a) 45(3) of the liquidation process makes it clear that under regulation 39C, the committee of creditor may recommend that the liquidator may first explore the option of selling the corporate debtor as a going concern under regulation 32E, or sale of the business of corporate debtor under class F of regulation 32. So therefore, the attempt shall be given by the liquidator to see that first they are trying to sell the assets as a going concern, then thereafter they can explore the other option given under regulation 32. Okay. Now this is one method. Now I am coming back to the corporate restructuring side. Okay. This is another mode of revival which we are discussing. Of course, now I'm done with that sale of corporate debtor as a going concern or sale as a going concern. But what are the other modes which I was telling? One is the CRP side, another is a scheme, third one is a liquidation sale as a going concern. So we are covering three aspects. One is CRP aspects, other is scheme aspect, third is liquidation sale, going concern sale during liquidation. Okay. Now what we have seen is liquidation sale on a going concern basis that we have seen so far. Now corporate restriction, you must be knowing what is that scheme. Section 230 we discussed all that. You must be knowing the routine thing, what are the purpose scheme will be done. It can be done in a merger, amalgamation, acquisition. There are many methods to do the scheme. Demerger, slump sale, joint venture, strategy, all these methods are there in doing the scheme. These are the law which we need to comply. Not only the Companies Act and Insolvency Code alone, we have to comply. We have to comply other laws also here. And these are the authorities which we have to dealt with during the scheme process. Okay. So scheme process, how it can be contemplated. So if you see section 230 as I was referring, it gives a power to contemplate. I referred the order of the Honorable NCLAT also, which says section 230 has to be followed. The liquidator first explore to receive the scheme. Okay. Now, one interesting point here is that it is not that by virtue of the order, the corporate restructuring is introduced in the the concept is introduced in the IBC, INB code. It is not so. Probably in the liquidation stage it is introduced, but in a CRP stage, if you see the definition of resolution plan, if you read that definition, it says very clearly, resolution plan means plan proposed by RA for resolution of the CD has a going concern in accordance with the part 2. Here the explanation has been inserted. Okay, sometime later of introduction of code. For removal of doubt, it is clarified that a resolution plan may include provision for the restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. That means the process of corporate restructuring is not that the the first time that has been deliberated in the court, it is there already in the code itself in the CRP stage itself. That's what I was referring earlier. So during the CRP process itself, in the form of resolution plan, the scheme can be contemplated in the form of resolution plan, and the due approval can be taken from the adjudicating authority. So this is very important point to note. Regulation 37, the resolution plan can provide for transfer of all of the assets. So all what is there in the through scheme, what can be done? Same thing can be carried out, can be implemented in the form of resolution plan. Regulation 37, sir, you see, it says what can be done. Restructuring corporate data by way of merger. That word is there in Regulation 37. Very important. Regulation 37, if you see, in fact, Regulation 37, I can take you, but the same language only is there. So what could be contemplated? Restructuring of corporate data by way of merger, amalgamation, demerger, all can be contemplated even during CRP itself. So the resolution plan can carry all these provisions. Okay. This only said there's a lot of deliberation, by NCLAT in Binani Industries and Swiss Ribbon case. After this only, an order came to be passed in this SEC and Amit Gupta, then Shivaram Prasad to Dhanapal, which we deliberated in much detail. We deliberated, I showed you the order also. Same thing in Mehel also. Same manner it has been deliberated in Mehel Homes in Supreme Court. If there is a proposal for a compromise, then the liquidator should make an application, then proceed within 30 days to file and to complete within 90 days from the liquidation commencement date. This is a very important point which we need to understand. So who can file? The member of creditor may, member or creditor, they can file. And this is the regulation 2B, which I showed you in the regulation itself. Compromise arrangement, where compromise proposed, the time taken for not exceeding 90 days shall not be included in the liquidation period, which I showed you also. Okay, now what can be merged? If you are discussing corporate restructuring, whether only the companies in India can be merged, there can be a cross-border merger. So I thought I can deliberate little point on that also, because we have got wide. It is not that only scheme can be contemplated between the Indian companies. Scheme can be, resolution plan can be given only by Indian companies. That means we can have a resolution plan or scheme can be contemplated wherein merger, demerger or merger between the Indian company and foreign company also can be done, carried out. So that's what I thought, okay, I can cover those aspects because it has been notified in September 13 itself. Okay, the merger and amalgamation of domestic entity, it's been notified. Cross-border merger has been permitted under Section 234 of the Companies Act. RBI issued a circular permitting the cross-border merger and amalgamation in March 2018 itself. So these are the laws which has to be complied with, which I was referring. These are related to scheme provisions 232, 240. This is not, if at all the scheme is contemplated under the IAMB code, these are the provisions should be kept in mind before proceeding further. So cross-border merger, which I was referring, can be done because FEMA also is opened up. What is the permitted thing? I'll show you what are the things. Structure of the compromise arrangements, types of amalgamation. These are the forms of amalgamation which can be done as part of the resolution plan. Even after the CERP, we have given a 90 days time to explore the scheme of compromise arrangement. For that, to implement that, we need to know all this. What is provided in the Provisions of Companies Act under Section 230 of the Companies Act. Because all this process, not exactly, but suitably has to be followed as may be directed by adjudicating authority who is hearing the application. These are the things which need to be followed, procedure to be followed during the scheme. I think now time is getting over. I'm not taking in detail, but these are the things that we need to follow. Cross-border merger, which I was telling you that Section 234 permits and Rule 25A of companies, compromise arrangement rule that also permits, and FEMA also, as I was referring, it's came out with a circular where it permitted. So whatever is permitted, mutatis mutatis, it is applicable to the scheme that is contemplated, cross-border merger, amalgamation contemplated under section 234. The same thing what is applicable to normal scheme, mutatis mutatis, it is applicable to them. And foreign company may, with the approval of the Reserve Bank of India, of course, they are giving a routine standard, same regulations only. There is no separate regulation introduced. As long as we are complying the regulation of inbound and outbound, and it is permitted under the FEMA. There is no separate regulation has been enacted in the FEMA for regulating or governing the cross-border merger. So foreign company incorporated, these are the requirement of the cross-border merger, which can be contemplated during the CRP in the form of resolution plan, and also can be contemplated during after the CRP period for first 90 days after CRP. So these are the jurisdiction. It is only the a scheme can be contemplated only the companies which are there in the countries which is provided in the schedule. A jurisdiction that has not been made, you have to know the countries that, these are the countries which is, you see, their names are given. So cross-border merger, you know that, which I explained to you, this amalgamation arrangement between the country, and these are the provisions relating to inbound, outbound of the FEMA. So since it is as a takeaway, just I wanted to give, these are the aspects has to be kept in mind while contemplating a scheme. That only I thought I can just cover these aspects also, part of my presentation. And there's a case law also, Jet Airways, where cross-border insolvency is very much implemented in this case law, when it has been approved by Honorable NCLAT. There's a parallel insolvency proceeding was going on, one in a Dutch court and other in Mumbai NCLT. There was a parallel insolvency proceeding was going on. So cross-border insolvency has been opened up, after this Jet Airways matter. It has got a certain clarity, and it reached certain clarity after Jet Airways insolvency cases. Thank you for your patient hearing. If any questions, you can tell me. We will discuss and deliberate. Then we can close the session. I'm done with my presentation. Madam, over to you.
Thank you so much, sir, for taking up the session. Session was very interactive and wonderful. Thank you very much for taking out time and giving a session.
Hope there is no question. We can close the session.
Yes, sir, sure, we can. Thank you so much, sir, for
Thank
giving
you.
us the time and taking such a wonderful session.
Thanks a
Thank
lot.
you, sir. Thanks for your wonderful
Thank you very
session.
much.
See you again. We'll see when term permits. See you again. Bye.
Okay, bye.